And guys, interns, if you could tell me when the live stream is showing. Is it showing?
Yes,
Showing, Judge.
Guys, interns, if you could tell me when the live stream is showing. Okay. All right. Let's go ahead and this is a motion to dismiss under Rule 91A. Counsel, make your appearances.
Marcus Olds for the plaintiff, Your Honor.
Daniel Rowland for the defendants, Your Honor.
And what is the name and cause number of this case?
This is Chang Gyu Ro versus Hanmi Foods, Inc. And
Okay, go ahead and Mr. Rowland, make your argument. I've read everything.
Yes, Your Honor. Before we go, there's only one thing that I think plaintiff might wish to talk about, and that is that they have a motion for continuance on file regarding this. We can talk about that right away, but right off the bat, regarding this issue, if you look at defendant's response, and Your Honor, I'm going to share my screen if that's possible so I can show you plaintiff's response. What we're trying to do in this is we're saying that Hanmi Foods is a Korean, basically distributor of different types of food. One of their delivery employees is said stepping from one surface to the other, that's their quote, hurt his knee or his foot stepping from one surface to the other while delivering boxes. And that's why he's suing us under a non-subscriber. An employee that he talked to when he hurt his foot, he called the office and said, I hurt my foot. And the employee who talked to him, they're also suing. So they said that this employee, whose name is Miss Choi, she's the second second defendant in this suit. They said that she was working in the course of her employment, and nonetheless, they were trying to sue her for negligence individually other than just the corporate defendant. And this is for negligence. So here's the defendant.
Mr. Rowland, let me ask this question because I want to make sure I'm kind of following the facts on this. So there's been an original petition filed, correct?
Yes, Your Honor.
yes, Your Honor.
Is there an amended petition that's been filed?
There was
There
an
is, Your
amendment
Honor.
petition filed 3 days right before, I think this was last Thursday. However, they kind of just doubled down. In their amended petition, they still are suing the same person for negligence, the employee, and they say we're suing her even though when we talked to her, she was in the course of her employment. So they just doubled down. They didn't really amend it in any way that addressed our special exceptions in our motion to dismiss. They basically just said, we're still going to sue her for negligence. We just were like to make clear that she was working in the course of her employment.
So let me make sure I understand this because I haven't read the amended petition. I only read the original petition. I hadn't seen the amended one yet. So, are they suing Ms. Choi for negligence in causing the accident, or are they suing Ms. Choi for making fraudulent statements to the plaintiff about something?
Well, it's unclear.
The lawsuit against Ms. Choi is for her own personal actions in supervising and directing Mr. Rowe. And so she is the tortfeasor for purposes of her own actions in supervising him, providing him with equipment, training him, and in instructing him to continue working after he complains that he's hurt himself, which causes further injuries. So there's a number of facts. So there's a number of facts which Ms. Choi's actions directly contributed to cause or aggravate Mr. Rowe's injuries. So we're not after Ms. Choi in her capacity as a shareholder or, an officer. I mean, I understand she is the owner of the company, but we're suing her directly as a tortfeasor for her own actions.
Your Honor,
And I
that's
think
what
in my
our
response,
is. I'm sorry.
I think in my response, I set out, I mean, this is bedrock law that, you know, and also, I mean, the defense motion is quoting out of the petition. Obviously, the petition does not contain the entire case. The petition is not evidence.
Your Honor,
So
91A's only focus on the petition. I think that that's maybe something that's unclear. When you're doing a special exceptions, that's why all this has to occur, and fees are mandatory under a 91A. This all has to occur before evidence, before discovery, other than attorney fees would mount. And what they say, black letter law, if the court would allow, I'm going to share on my screen the case that they think is black letter law. I'm going to just share the response by the other side, because our clerk here, who I'm going to introduce, Sydney Brown, this black letter law that we saw from the court is actually copy pasted from this other case. And we're going to show you where it's copy pasted from. And this is a case that actually got the court mandamus for doing exactly what the plaintiffs are asking the court to do. It's called in rebut. I'll show it right now. If you can, I'm sharing my screen right now, if we can do this. On the right
well,
here,
unfortunately, I don't have the benefit. Okay, this may, if I can interrupt for a second.
Here.
I mean,
don't
I don't have the benefit of seeing this.
Well,
because,
I mean,
because I'm in a place where I have cell service but not internet, and that gets me back to the point of, you know, we've had asked for a continuance because I'm on vacation, so I'm calling in, you know, from a remote location here.
Well, Your Honor, we're just going to show that we're going to say it's copy pasted from this case. We're going to show the court that it's copy pasted. And then we're just going to show the court the Texas Supreme Court law that has the exact same fact pattern as this. All the plaintiffs' cases are about DTPA. The Texas Supreme Court in 1996 and Leach Hornsby has this exact fact pattern of it, basically an injured employee trying to sue the corporate officer or the corporation. And it goes through here and it says the problem is duty. The employee does not have a duty to the other employee. The employer is the one who has the duty, so you can't sue here. It's called Leach versus Hornsby, and it says an injured employee brought a negligence action against his corporate employer and two of the employees. The Supreme Court holds that officers cannot be held individually liable for the employee's injury because it's negligence. All their cases address DTPA. They're flat out wrong. And when I talked to Mr. Olds on this, and their response, which is kind of odd, actually quotes an entire case from in rebut, and which will show the court right here. This is in rebut. It's exactly the same. I mean, it's word for word copied. They didn't change a single thing in the entire thing. And the thing the case they copied it from, this in regard but, the court actually got mandamus for denying the motion to dismiss, which is exactly what they're asking for. So we know why they didn't let the court know which case they were quoting from. If Ms. Brown, our law clerk, hadn't found this, we would have never known about this mandamus case. But
I'd just like to respond when you're finished.
Yeah, I mean, I can finish right there.
So the case that you're quoting and the mandamus addresses a lawsuit that occurred between an injured employee and an officer of the company in the capacity as an officer, which is what the defendant is trying to shoehorn us into having sued for. But this is completely distinguishable because we're not suing Ms. Choi in her capacity as an officer. We're not suing her in her capacity as a shareholder or anything else. We're suing her directly as a tortfeasor for her own personal actions, which is different than what you're talking about, Mr. Rowland.
No, it's actually not. We're saying it's in between an employee and employer. In non-subscriber cases, this Supreme Court case that talks about it's whether you can sue the employer or the employee. And I'll just read from the case because it seems like...
Can you share screen this case you're talking about?
This is the Texas Supreme Court case. It is Leach versus Hornsby. It is 935 Southwestern 2nd Edition.
Mr. Rowland, can you share screen that case so I can see it?
Oh, I definitely can, Your Honor. Here we are. Can you see this, Your Honor?
Yes.
And I am now going to go down to the language that is actually directly applicable to this case. And we are on applicable law. Actually, we skipped it. I went past. Applicable law is right here. It talks about an employer is not the insurer right here in the applicable law. For decades, this court has recognized that the duty is not right. All right. So that when the employer is a corporation, the law charges the corporation itself, not the individual corporate officer within the duty to provide the employee a safe workplace. So that's it. So in this case, they were complaining that there was someone who didn't do what they were supposed to do within the company, and they were suing them. And so here we go, the applied law to the facts, and this is the most important. The jury found that Procam, Leach, and Cruz, so the company and two individual defendants, were negligent and responsible for the injuries. However, they found that Hornsby was the employee and failed to find that the employee was alter ego. So when there's no alter ego alleged, and they haven't alleged this in the petition, what you have to find is an independent duty. And that's what they're saying in this case. And what this case says is there's an employee does not have an independent duty to another employee. The one who holds, and they say, a non-delegable duty. It says here, Leach and Cruz, the individual defendants, were not Hornsby employers. The jury found that Procam was Hornsby employer. As Hornsby's employer, the company had a non-delegable duty to use ordinary care in providing Hornsby with a safe workplace. They have to prove an independent duty. The only way that there'd be an independent duty in any one of these cases is, if you're driving, you have another independent duty to other drivers. So you have to find, and they don't allege any independent duty. It's just one employer with another employee. They called our employee, who was a supervisor. They said she was working in the course of her employment. She had a conversation with this person, and now they're suing her, even though she was just working in the course of her business. That's just not what's happening. And that's what exactly this case says. And the Dallas Court of Appeals and the entire Texas jurisprudence cites these cases every single time there's a non-subscriber negligence case. And yet the other side, plaintiffs, in all their law, just cite DTPA cases.
Can you go down a little bit on this? Go down.
More?
Yeah. Okay, never mind. All right, so.
And then it goes up to the top here. And so they're right if this was a DTPA and all their cases say, but that's because the statutory language is different. In negligence, you need to prove that there's some sort of other type of independent duty. And there is none in this case between an employee and another employee. And we showed them this case beforehand when I talked with I didn't show them this case, but I told them the synopsis of this case, and they just told me, no, we can sue this person regardless. And I think they were reading DTPA claims.
Did you said you did not provide this Leach case in any of the briefing?
I did not provide this case, Your Honor. So I guess that's on me. I just read the standard of in negligence non-subscriber cases. This is just like the first 15 minutes of a continued law education course. This is the first thing they go over, which is an employee does not have an independent duty to another employee. It's the employer that has the non-delegable duty to use ordinary care in providing a safe workplace, and that's what's violated. So there's no duty here. And that's why we told them on the special exceptions, you need to get them out. And that's why we wanted to get their out before any additional discovery goes through, because attorney fees here are non-discretionary and mandatory, which is the reason why all these things have these date deadlines and have to be done 60 days within the filing of the citation. So that's why we are kind of against the wall here, is we don't want to rake up our attorney's fees on a mandatory non-discretionary matter in which this lady doesn't need to be in this case at all because it's black letter law.
When was your motion to dismiss filed?
Our motion to dismiss was filed on May, let's see, we filed this on July 1st.
Oh, July.
Filed it. The notice of hearing was on July 4th. We did our motion to dismiss was filed May 24th, Your Honor.
All right. So I unfortunately, I kind of agree with Mr. Rowland that I think this is probably the law, but I don't think it's fair to the plaintiffs to not give them an opportunity to respond to this case since it wasn't cited. So I'm going to give the plaintiff an opportunity to provide a letter brief about this leach, and leach is 935 Southwest 2nd 114. I will say that it's always been my understanding that you can't sue a co-employee in a non-subscriber case as well, but I haven't looked at the law recently, and this is kind of an older case, so there may be other law out there. Usually my deadline would have passed to rule on this. I usually would have 45 days from the date of the filing of the motion, but under the Supreme Court orders giving the trial bench an opportunity or the power to extend deadlines, I'm going to extend the deadline for this for a month to give me an additional month to do this. So you're going to need to provide me a letter brief on this.
Your Honor, I'm sorry to interrupt. I gave you the wrong date. Ms. Brown just corrected me. We filed our motion to dismiss on June 24th, not May 24th. I don't know if that changes anything for you. No, not really. I mean, it means I still have time to rule on this, so that's, I guess, good, but I can extend it. I'm also going to extend the time for the plaintiffs to be given the kind of the strangeness of the procedural history here. I'm going to extend the time for the plaintiff to get, so you have 2 weeks to file a letter brief and you have an additional week to non-suit this party under the emergency rulings of the Supreme Court. So you guys will need to do an order on that. I would urge you to really look at the law here, because if you don't non-suit this party and you're wrong, I have to award attorney's fees against you. And I think you probably are wrong. So I'm trying to give you a break here, but do you have any questions, plaintiff's counsel?
When will the deadlines be due again so I can take that down?
So a week from today, you have an additional week to follow your non-suit of the Ms. Choi, I guess her name is. Usually it would have been 3 days ago, or 3 days ago. I'm giving you an additional week. And if you decide you want to fight this out, you have 2 weeks from today to file a letter brief. And I'm extending my deadline to rule on this to 30 days. But I would highly, highly recommend you take a careful look at this case law before you head forward, because it's mandatory attorney's fees against you if I have to dismiss this and under 91A. And I think you're probably wrong on this. So unless you find something that that overturns this case, I would highly recommend that you non-suit this case and avoid the attorney's fees. Or non-suit the case against Ms. Choi and avoid the attorney's fees.
So the deadline to non-suit would be July 27th. And
Yes.
If not, the letter brief is due August 3rd.
Yes.
Okay.
Mr. Rowland, get me an order that indicates that and email it to my court coordinator and to opposing counsel.
Yes, Your Honor.
And Judge, just to let you know, I mean, my co-counsel obviously is still in Texas, but I was handling this issue and I'm out until the end of this week, actually. And I'll be driving back to Texas Friday night. So with that, is there a way to move these deadlines back an extra week, or is that all the authority of the court has?
I'm giving you a humongous break here. I really should probably award attorney's fees against you right now, but I'm giving you an enormous break by giving you this extra time to file the non-suit.
Okay. All right. Thank you, Your Honor.
Thank you, guys. Give me an order.
Your Honor.
Thank you. Bye-bye.
Bye.
Okay, let's see who's still here. Okay, Rhonda, Tony, our next hearing is at 1:30. I'll chat with y'all real quick about the hearing we just had.
Judge, you're still on YouTube.
Oh, oops.